Judges, now we know, colluded to schedule trial dates against Donald Trump, racing to get him convicted before the 2024 elections so they can say a felon is running for the Republican nomination and running for the presidency, and they can use that in their political campaigns and so on. But there is new news that there was collusion between Judge Juan Merchan and Judge Chutkan in scheduling these trial dates because, as we know, Trump got charged with 4 different criminal cases in 4 different locations, all in 2023, simultaneously back to back, one right after the other. So in 2024, when they tried to schedule their dates before the election, there was this question, who goes first? Many of these are going to be 2 months, 3 months, maybe 6 weeks. So there's only so much time. And so Judge Chutkan was the one who came out first. Remember, her trial was scheduled to already have been started until Trump appealed her on the immunity issue, which is now at the Supreme Court. But when her case got deviated, they slotted Judge Juan Merchan's right back in front. They got 4 different eggs to play with. They moved him front, and he was already delayed for a while. And so this is a new filing that is now public. This was submitted some time ago in this case, but Todd Blanche posted this over on his website at blanchelaw.com, where you can find all of these filings because he is making them publicly available for us to read because the court will not do that. So we pulled this from him, and it literally is from Trump's attorney. So you'll see this. This is the signed affirmation of Todd Blanche, and he's explaining to us what he has seen. Now let's take a look at this. He says, first of all, we want a reconsideration of this trial date because there was collusion to schedule this, but also we want your ex parte communications, Judge. This is going to Judge Juan Merchan in New York. We want your ex parte, your private third party communications, or not third party, but not single party, essentially, right? Not both sides. The judge should be talking to both sides. Why are you having external conversations with Tanya Chutkan, the J6 judge there in the DC courts? They want to know what those conversations were, and they want them to be documented on the record. Signed by Todd Blanche. And again, all filings available, blanchelaw.com. Check them out, spread them around like wildfire. We got this one from Todd Blanche. He says, all right, look, this is my affirmation saying that we need to get this collusion on the record. Says, look, I represent Trump in this matter, and I submit an affirmation saying we need to get the record of the substance of the ex parte communications between Merchan and Chutkan documented. Saying my affirmation is supplemented by my personal knowledge and my personal belief I represent Trump in multiple cases. In particular, this includes my participation in court proceedings and other aspects of the case, and for the reasons set forth below, I think that your communications with Judge Tanya need to be documented because they have prejudiced Donald Trump insofar as these communications have resulted in trial schedules that are fundamentally incompatible with Trump's rights. Blanche says, look, Judge Juan, as the court is aware, trial in the above captioned case scheduled to begin on March 25th. Now, this was filed earlier, so now it's the 15th, right? The judge postponed it 3 weeks. Thanks, Judge, after they dumped in a bunch of discovery. Now, May 11th was when that got scheduled. Now, since scheduling the May 11th, the trial date back in May, okay, so Bragg's case got scheduled for trial in May. So just think about how all these got moved. Trump has been indicted twice by the special counsel. Grand jury Florida, grand jury DC. In the Florida case, that trial is scheduled to begin on May 20th. Probably not. And Cannon was aware of this. Now, at August 28th, this is where some of the collusion comes in because they're trying to jockey these around. At conference in DC, Judge Chutkan, she set a trial date for March 4th, which is come and gone. Judge Chutkan was also aware of the trial schedule set by this court, and the March 4th trial date was over the strong objection of Trump. Now, the DC case, they say it's going to take 6 weeks, and that estimate does not include jury selection, openings, summations, defense case, jury deliberations at all. The J6 case is 6 weeks just from Jack, not even the defense. Time is there. Now, although the exact length of the DC case is impossible to predict, likely that it's going to last more than 2 months. So in both written briefing and at oral arguments in the DC case, counsel for Trump alerted Chutkan to my obligations as lead co-counsel in this case. So saying, hey, Judge, so Blanche is in 2 places. Another attorney in Chutkan's courtroom alerted Chutkan to Blanche's obligations in New York, as well as Blanche's representation of Trump in Florida. Now, Chutkan acknowledged the competing demands and still set the case to start on 25th, actually knowing that this was scheduled on March 25th. So in other words, Chutkan put hers first, right? March 4th, they said, no, we got one March 25th. And during that, right, we're wondering, wait, we can't be in 2 places at one time. So Chutkan scheduled hers for the 4th, and the judge in New York scheduled his for the 25th. So back during the hearing, Judge Chutkan Chutkan also indicated, she said, well, I did speak briefly with Judge Mercan to inform Judge Mercan that she was considering a trial date that might overlap with this case. Okay, so these two judges are talking with one another. And it's interesting to see how this all unfolded. And I remember that, right? So the trial date was scheduled first in New York. Then Chutkan said, no, I want that block. And then they moved the New York case. They said, perfect. The J6 case, that has priority. You can have it. Now, so they talk. Okay, so Chutkan and Mercan are having this conversation, and they give us some background on this. Here you see March 4th, 2024 trial date was over the strong objection of Trump. That was in the Chutkan case. Now, it's been crazy, the amount of preparation that they've been required to do. They say it's been extraordinary. In the DC case, where Jack's office continues to produce discovery, Trump has gotten more than 8 terabytes of data, 13 million pages of discovery, grand jury testimony, hundreds of interviews of witnesses. Similarly, this case in New York has more than 2 million records, insane, spanning 10.5 million pages. They're burying them in discovery, potential witnesses, connection with overlap. This case has been going on for years. Notably, Bragg has indicated that further productions will be made on an ongoing basis, and we've got a lot of other work to do, and nobody cares. They say despite this, and despite Trump's objections that a March 24 trial date's inconsistent with Trump's due process rights, Chutkan didn't give a crap, scheduled it anyways on March 4th. Now, Todd says, now because Judge Chutkan's ruling created a clear conflict with Your Honor's schedule, I wrote to you, Your Honor, on August 30th, which we have not seen, respectfully requesting a status conference to discuss the scheduling conflict that has arisen. I attached a copy of my letter in case you forgot. After initially agreeing that a status conference was appropriate, Your Honor replied to my letter declining my request. You stated, in light of the many recent developments involving Mr. Trump and his rapidly evolving trial schedule, I do not believe it would be fruitful for us to conference on this case to discuss scheduling. We'll have a much better sense in February whether there are any actual conflicts, and so we'll see then. Now, under Your Honor's order, President Trump and his counsel must simultaneously prepare for 2 trials in 2 separate courts with 2 separate charges, facts, and witnesses that overlap with each other, and we must wait to address the currently existing trial conflict until February 15th. Now, in light of the untenable conflict by this, Trump asks for a new hearing, and Trump also respectfully requests that you inform the parties, right, Judge? You and tell us of the substance of the ex parte communications between you, Judge Mercan, and Judge Chutkan concerning the competing trial schedules so that you can actually add them to be a part of this case. And reconsider your reasons for not postponing this. We need a new trial date. If you don't give us a new trial date, it is going to jeopardize Trump's right to a defense. Trump doesn't have the ability to even adequately assist in his defense. He doesn't have the right to assistance of counsel since we can't review all the materials needed to do our jobs, or his right to be personally present. Now, the constitutional guarantee is fundamental. 6th Amendment says we have these rights. A lot of case law here. And interfering with this is a problem. As a constitutional matter, we also have the right to be present. And so counsel and President Trump acknowledge we respect the importance of judicial efficiency. Like, we know that judges talk and move things around, but counsel and Trump are not seeking to inappropriately delay this at all. But it's undeniable that Chutkan's decision to set a trial for March put Trump in a precarious position. By her own account, she's well aware that by scheduling the DC case for trial, which was this is now off, she was literally creating a conflict for him, right? The fact that that trial date got moved doesn't mean that Chutkan wasn't trying to override this judge, and was like Chutkan was knowingly creating a conflict for the president, knowing that another court had scheduled a trial, right? So why did Mercan give way to Judge Chutkan? Could it be because she's a federal judge? Because it's a DC case? He called it yesterday in his proceeding, his filing, the federal insurrection matter. Does he think that's more important in this case? Like, what's the substance of their conversation? What did they say? While noting the conflict, Judge Chutkan acknowledged, as she must, that yeah, Trump does have a right to be present at both trials, as well as the commitments and the obligations of his counsel to prepare for them. Now, despite this, and despite her so-called brief, discussions with you, Mercan, about these trial schedules, the trial in DC is scheduled to begin 21 days before this one, right? Like, they did that intentionally. Then they moved him around. So she scheduled his, then he moved theirs, then Court of Appeals took up the J6 case, and so this one's back on. And Your Honor has denied counsel for Trump the opportunity to discuss this critical case until recently. So the court's decision is a problem. It calls into question whether Trump will have a fair trial, since you two are colluding to stack his trials on top of one another. Trump has 8 terabytes of data to review, grand jury testimony, hundreds of witnesses, SEPA filings, we got Florida, we got numerous motions, deadlines. It's insane. We got 10 10.5 million pages of discovery, the volume of which is going to continue to grow, and it's all being dumped on us last minute. And so counsel recognizes that you're intending to proceed on this going very soon. Even if it's competing with Chutkan, it's totally inappropriate to even do this to us. And waiting until February to discuss another trial date and see what happens, Your Honor is aware that it would be a waste of court resources and other people to begin preparing for this, not knowing whether it's going or not. And finally, it's inescapable that the circumstances before this court today are colored by Your Honor's discussions with Judge Chutkan prior to her ruling. This judge keeps talking to everybody, man. He has the Office of Judicial Administration just act as PR extensions of his daughter. He goes and gives interviews with the media, talks about the case, even though Trump's defense said, hey, can we have a hearing on pretrial publicity? The judge said, nah, we'll talk about pretrial publicity after I'm done with my pretrial publicity. You know what I mean? So they say, Your Honor, ridiculous. The judge shall not initiate or permit or consider ex parte communications or consider other communications made to the judge outside the presence of their parties about the proceeding. Don't talk outside the courtroom or outside the parties. We want to hear what's being said. And although there are some enumerated exceptions, including one exception that allows the scheduling and other administrative purposes, the rules say the judge should generally disclose the substance of those communications with their parties so that we can see what you're talking about. And again, right, if this is all above board, if there's nothing nefarious that they're talking about, and we don't have anything to worry about, why wouldn't they just publish it? They don't want to even publish anything. The defense objects to these ex parte communications with Judge Chutkan, as they appear to have impacted Trump's constitutional and statutory rights and will prejudice him severely if you don't move the trial, or at least timely discuss the possibility of the adjournment. Now, we understand from Chutkan that she informed Your Honor that she was, quote, considering a trial date that conflicted with you. Now, beyond that representation, we are not aware of what Your Honor stated to Judge Chutkan or any other communications between you two. Now, as a matter of fairness and to ensure the record is complete, we respectfully request that the court inform the parties about the substance of Your Honor's communications with Judge Chutkan. Signed by Todd Blanche, an affirmation for him saying, put it on the record. And of course, that is not going to happen. The judge has already denied making these public, said we've already made enough public, you've gotten enough. Here's an email that came in. This one looks like it's from Susan Hoffinger to the judge. It says here, hey, dear judge, per your request at our court appearance, the people have conferred with the defense about a trial date. We're prepared to start in February. March 25th, says the people, this is from Bragg's team, will be ready. And this is from the judge back to Hoffinger. Says, counsel, although the date proposed by the defense provides much more time between decisions on motions than is necessary, this matter is hereby set for trial on the 25th. Now it's on the 15th. All parties, including Trump, are directed to not engage or enter into any commitments that will prevent you from starting. That this is a date certain. Please be advised, the court will not consider any change of counsel unless they're also available to start on the 25th and continue through unabated. Thank you, the judge. Joe Tacopina, many other things. You're on the case. You're on the case. So that's what came in, and it's now public. So you can see, right, how these judges are just orchestrating this to get Trump. They want to make it happen, and they're working hard to do it. So this is Alan Dershowitz. He's right next door on YouTube, on Rumble, on all the places. And he was asked about this, and he's been practicing law quite a bit of time. And here's what he says about what's happening there in New York.
This is the weakest charge I've ever seen in my 60 years of practicing and teaching criminal law. It's a made-up case. There's nothing to it at all. But there may be a conviction because it's New York. And in New York, they'll convict a ham sandwich. If it has Trump's name on it, the case should have been moved out of New York City into Rockland County or Staten Island or some other place where there's a chance to get a fair trial. But gag orders are presumptively unconstitutional because they involve prior restraint. And the First Amendment doesn't permit prior restraint. There's a narrow area where you can have a gag order where you're going to disclose evidence that shouldn't be disclosed or you're going to tamper with juries. But here's a case where this judge is making a decision helping his own daughter. What could be more of a conflict? And wrongly doing so. This young woman who is an adult and works for a political Democrat company that represents Adam Schiff, the man who headed the Judiciary Committee efforts to impeach Trump, will benefit financially if Trump is convicted and will lose financially if Trump is acquitted. So he certainly has the right to make that public, more so because this is New York and it's a rigged case, essentially, and he's entitled to do that. And I hope his lawyers appeal the gag order, and I hope they appeal the recusal order.
All right, so we'll see if that happens or not, but that's Alan Dershowitz. Make sure you're giving him a follow on all the platforms. I think a good take there. Absolutely rigged, and the judge is no better than Engoron. Actually, maybe worse than Engoron. Engoron didn't have a daughter that was working and raising money money for Trump's opponents, as far as we know. But we're going to be here continuing to cover this one as well, my friends. Trump demanded a new trial date. I'm not so sure that's going to happen. The Court of Appeals, someone is going to have to come and take this away from Judge Merchan, and the clock is ticking. We are going to be here to cover the New York trial. It's very likely going to be reading through excerpts and other people who are in the courtrooms reporting on it live, since it will not be televised. And so we'll be here covering it. I do hope you join us as we do. Would love it if you invited someone you know or love to come over here and join us when we go live, come watch some of this content so that they can see what's happening behind the scenes in this case and the others. We got great links down in the description below. Watchingthewatchers.locals.com is our members only community where we dive into other political issues, other cases, other topics, 2024 and whatever else is happening out there. We do streams in the morning, streams on Saturday. We have a great members only community. We'd love to have you. And we have Sovereignty Saturdays now at watcherlodge.com, all free. We're hanging out for about an hour, 45 minutes or so, talking some sovereignty and self-development things, hitting the highlights, checking out what the latest alerts are from our various government entities, and trying to learn some stuff and have some fun community built in the meantime. So check out the links in the description below, my friends. We'll see you over there and back here on the next one.